Tamara Ugolini here with Rebel News to bring you an update on just how prevalent mask madness remains here in Canada. This particular case comes from the province of Alberta, and it came as a result of chiropractic Dr. Curtis Wall, who has been facing reprimand and investigation by his regulator, that's the College of Chiropractors of Alberta, due to his inability to safely wear a facial decoration, otherwise known as a cloth mask, throughout the COVID-19 pandemic hysteria. And due to this inability, he did not force his patients to wear masks either, and instead upheld the mandate itself, which always stipulated mask exemptions. His lawyer, James Kitchen, previously joined me to discuss the science around community masking and how it was finally seeing its day in court, with robust academic experts testifying with their expertise on the topic. But it's more of a kangaroo court than anything based on solid evidence and facts, and so it went exactly how Kitchen anticipated it would. And that's because the college's own expert presided over the four that Kitchen brought to the hearing. And it's likely because that lone expert was riddled with conflicts of interest and, from what I could see, likely corrupted by the COVID-0 cult. Let's hear how things went with lawyer James Kitchen himself. Have a listen. You provided 4 expert witnesses on behalf of chiropractor Dr. Curtis Wall versus the college, who had to really dig to find just one expert. And this particular expert is Who, which I discovered was the CEO, or is the CEO, of COVID to Zero. This idea that, indiscriminate lockdowns and mandates could squash the spread of a seasonal respiratory virus. Can you give us some insight as to what that looked like, having, this one public health position, and what that even is, versus the 4 really esteemed experts you brought to the table?
Sure. So, it was the typical kind of thing, right? You have this, quite obviously pro-lockdown, pro-narrative, kind of hip, young, woke public health physician that was the expert. And I mean, that was expected. That was predictable. I didn't expect some, serious gray-haired academic to be the expert. I mean, it's really difficult to defend these things. It was difficult to defend at the time, even when it was sort of in vogue to do repeated lockdowns. Obviously, it would just be academically embarrassing to defend them now, and some people are starting sort of to distance themselves from what they did back then in recommending all this nonsense. So I got 2 retractions of his evidence. I cornered him a few times on how much he insulted my experts, or Dr. Wall's experts, which again is just sort of almost bizarre. That type of thing, if you did that in court, I mean, a judge would really have a hard time with that. The tribunal, of course, sort of glossed over that. Actually, they ignored it altogether in their decision. And they ignored the retractions too, which no reasonable judge would do. If an expert makes retractions, you highlight it in your decision. Otherwise, you're not a competent decision maker. Tribunal ignored that, right? And they had to, right? In order to give some sort of justification to the bizarre pro-narrative conclusion they arrived at, they had to shove a lot of evidence under the rug that was really inconvenient. And that's a lot of what they did with Doctor Who. So yeah, you have this guy who's a public health physician. So I mean, I guess that means he knows about public health. I mean, I've never really quite understood what that is. I mean, obviously it's to do with the health of general populations as opposed to a private, individual patient. I get that. But it's never really quite clear what that is, or why that's actually a really specific or a discipline that has a lot of deep knowledge behind it. Just more sounds like a sort of a paper pusher position. And that's actually a lot of what this guy was. He talked a lot about how he had been involved in writing some of these orders, and being involved in advising the people writing these CMOH orders and stuff like that, right? But as far as actual knowledge, epidemiologically, vaccinology, immunology, he lacked that deep knowledge. He's basically just sort of a non-clinical sort of paper pusher kind of doctor. It's not to say he wasn't a doctor, he was, but that's the thing, right? And I intentionally brought in 4 people who had very deep, specific knowledge relevant to what was going on with COVID, right? a vaccinologist, an immunologist, a respirologist, right? A medical microbiologist, an infectious disease consultant who was getting his master's in epidemiology at the London School of Economics. I mean, these are academic heavyweights I brought in, right? And they had precise, specific expertise that was intentional. And then, of course, I had Chris Schaefer, right, who's the occupational health and safety consultant, who was sort of the other side of this thing to talk about the harms of masks, because of course the first three are really to talk about how ineffective masks are. So you have this one expert. So first of all, it's only just one, but he's got very surface level knowledge. And then I had three sort of academic medical professionals or scientists who had much deeper knowledge in three areas that public health physician was, completely over his head in. And of course, he had actually absolutely nothing to say in response to what Chris Schaefer had to say. So it really was kind of a no contest, and that was by design, right? Because I mean, obviously, I expected the tribunal to rule the way they did. I expected them to hold the narrative. I expected them to rule against Dr. Wall. I expected them to do whatever the college asked them to do. I expected that, right? So I've set out to say, okay, well, this isn't necessarily about winning. Unfortunately, it's not like I'm going to meet a neutral, unbiased decision maker. I'm going to set out to set up for the world to see a contest between the real science and the politicized nonsense that is the pro-COVID narrative. And that's exactly what I did. And, so now the tribunal, they ruled the way they have, but it's really, really, really difficult for them to be able to say, well, we just didn't have access to the science or the expert evidence, or it just wasn't clear. Or, they can't get away with that if people actually would pay attention and take the time to read the material that's publicly available on the Liberty Coalition Canada website and sort of hold the tribunal accountable. Which is what you're doing, and I really appreciate it. Good, right? It needs to be done, and that was really my whole goal with this. Which is sad that that's the state of the law in the country, but I'm aware of that, and that's why I set up these things the way I do.
Mm-hmm. And I mean, all of that aside, what is the structure of this tribunal itself in terms of who's running the show there that really decided to rule on the side of this one surface level expert in direct opposition to what you showed with, again, these deeply knowledgeable academics?
So there's a number of problems here. I mean, first of all, the tribunal had 4 people on it, and you don't put an even number of people on a panel. I mean, you're never going to go to a court that has a panel of judges and it's going to be 2 or 4 or 6. Normally a panel is 3 or 5. So there's that. Then there's the fact that there's 2 public members on this panel and 2 chiropractors. Well, it's supposed to be self-government. So why do we have 50% public? Why is it public? Why is the public governing the chiropractic profession? The chiropractors aren't governing it. The government isn't directly governing it, which might be acceptable. Why is it the public, right? Why is it, we want public representation, but we don't want them 50%. So that's a problem. And then, of course, you had a public member who was chairing this. And he happened to be an elderly man who visibly fell asleep once during the hearing. And that obviously doesn't instill confidence in anybody, and it's not a proper way to do things. And so the whole thing was really, it's really too bad. But then you have, of course, 2 chiropractors. Okay, so they represent, the professionals, right? And chiropractors, right? They're medically trained. They receive a lot of science education. They're not dumb. They're pretty smart, a lot of them. And so they're there, and they're there kind of the voice of reason. I mean, I get the fact that the public members are just going to be soaking up the narrative, right? That's all they did for 3 years. But the chiropractor should have been the voice of reason. And what we should have had in this case, if the public members were determined to rule against Dr. Wall, we should have had a dissent written by the chiropractors that said, look, we looked at the evidence, and I know it's unpopular to say, and I know it's counter-narrative, but look, the evidence is clear. The masks don't work. They didn't work. They never worked. And Dr. Wall was in the right by not wearing one and protecting his patients from having to wear one, right? But, unfortunately, the 2 chiropractors, and you can see their names on the Liberty Coalition Canada website. Their names are public now. Their names used to be protected by a publication ban that I got lifted. So that's another thing, right? This whole thing was covered under secrecy for a while. The tribunal wanted to make this case entirely secret. They succeeded partly for a while, and that should concern everybody as well. Why would they make this case secret, right? You make cases about sensitive, cases involving minors and sexual abuse and stuff like that. You make those cases, a secret because they're sensitive. And the only reason people want to listen to them is because it's salacious, right? Here, this is of utmost public importance, and the tribunal and the college is trying to make it secret. Why? Right?
Mhm.
So,
Well, and it all lends to the fact that this really seems more like a kangaroo court than anything that operates with checks and balances. So the tribunal ruled against you despite the fact that the evidence was robust and clear. What is the next step here?
the next step is appealing to the college itself, so the council of the college. So every one of these health colleges has a board or a council, a group that is made up of public members appointed by government, appointed by cabinet, and the actual professional members who are elected by the wider professional body. So there's 10 people on this council, which again, I don't know why it's an even number or such a small number, but there's 10 people on this council, 5 public, 5 elected chiropractors. Okay, so here's the interesting thing, right? Some of them are going to be potentially up for re-election. They're obviously under a mandate to represent their members, to represent the interests of chiropractors, not the interests of the woke mob or the pro-COVID people or whatever. They're supposed to represent the interests of chiropractors. So now it's in their lap, right? So these 10 people, and especially these 5 chiropractors, have the opportunity to look at this decision and say, okay, that was decided wrongly. Obviously, we have the evidence in front of us. We get it. We know it's a COVID thing. We know that's controversial. We know there's a narrative and we're expected to follow it. But my goodness, this isn't right. We're going to overturn this. They have that opportunity now. And now the members who elected them or who might re-elect them and who have to pay the fees, by the way, that are paying for this case, which has already cost over $200,000, they're the ones that get to say to these 5 people, this is ridiculous. And you know it's ridiculous. And I expect you to do what's right. And I expect you to overturn this decision. Stop wasting my fees on this. Stop persecuting us for your political narrative. Fix this. They have that opportunity. And it'll be interesting to see what they do. And if they don't, then it's off to the Alberta Court of Appeal after that.
What's the time frame on something like this? And in the meantime, I suspect that Dr. Wall is practicing unabated.
Dr. Wall practiced this entire time without wearing a mask. They tried to take his license, they tried to suspend it on the basis that he was an imminent threat to public safety by not wearing a mask. They failed in that, and that's when I first got involved. And so he didn't wear a mask this entire time. And there was never any evidence of any harm to his patients. None of his patients ever testified that they were upset or felt unsafe. In fact, I called 3 of his patients to testify that they were very grateful that he didn't make them wear a mask. And the tribunal completely ignored that evidence. So as far as the timeline, I'm probably looking at appealing to council in the summer or fall. We have to go through the discipline phase. That's where we're at right now. So we have the findings that there was unprofessional conduct. Now we have to move into what's it going to be for penalty, right? So is the college going to try to get a really heavy penalty, or are they going to have, agree to something very light because they'd like to see this go away? That's what we're going to see next. Only when we have a decision from the tribunal, who's still seized on this matter, they're going to make a decision on penalty. Only then do I appeal to council. That happens pretty quickly because there's timelines in the legislation that makes that happen quickly, and then I would go to the Court of Appeal, which would be a bit of a slower process. So it'd be interesting to see with this penalty decision too, because the tribunal, like, their names now are public. They used to be protected under the secrecy ban. Now they're public. So it'll be interesting to see if the public, tries to hold the tribunal accountable by showing up to the hearing and talking about it in the media like it's happening now, and if they'll feel that at all and respond accordingly. Before I let you go, and thank you for indulging me, is that I want everybody to notice that if you think I'm blowing hot air, pull out the decision, the 87-page decision on the Liberty Coalition Canada website, and note one thing: there are no citations to the record. There's 1,400 pages of transcript evidence in this case, and there isn't one citation in that decision to that record, to that evidence. If you read this decision, which, by the way, all that's available on the college's website is the decision. If all you had was the decision in front of you, you'd have no idea if the tribunal was making things up or actually following the evidence. But you do have access to the evidence because it's all on the Liberty Coalition Canada website. And you can go to my factum, which has 130 citations to the record, and you can see how I cite the evidence. The college doesn't, because if they did, it wouldn't work. Their conclusion, you couldn't arrive there. So just to give one really glaring example as an error of fact, the tribunal put a lot of weight on the fact that apparently all 4 of Dr. Wall's experts said that they did or would wear a mask when they were required by authorities to do so. But that's not accurate. 3 out of his 4 experts did. The 4th, Chris Schaefer, God bless him, he was asked the question on cross-examination. Would you wear a mask to keep your license? Chris Schaefer held a license with the College of Paramedics of Alberta for 1 year. He was asked, would you wear a mask to keep your license? You know what Chris Schaefer said, no, I wouldn't. My health is too important. I would give up my license. I would not wear a mask. The college then turns around and says, all 4 of Dr. Wool's experts said that they would wear a mask if required to do so. Blatant error of fact, right? And of course, because there's no citations to the record, and because normally you wouldn't have access to the record as a member of the public, how would you know if the tribunal was making that error? You can go see in the record where Schaefer had this interaction with the lawyer for the college. It's really quite spectacular. I didn't actually see that coming. I didn't know what Chris Schaefer was going to say. But that's what he said in the tribunal. They didn't want to get that right. I have a hard time believing that was an innocent error, because when you make that kind of error, that obvious error, is it mere incompetence? I have a hard time with that. So that's just one example of a glaring error of fact. Those types of errors of fact I don't often see as a lawyer. Decision makers are usually sharper than that. They don't make errors that bad. So the college the college had brought charges against Dr. Wall saying, look, it was unprofessional of you to not tell your patients that masks work. In other words, because you told the truth, because you told your patients masks don't work, we're going to penalize you for that. That's compelled speech. When you don't say what somebody else wants you to say, and they then penalize you for it, that's compelled speech. It's punishing you for not saying what they wanted you to say. Okay? That's what compelled speech is. So I made that argument that, look, this is compelled speech. The college told him to say this. He didn't. He said something different, and now they're penalizing him for it. And the tribunal just made a mess of that analysis. They just had no idea how to approach that. Granted, that is a complicated area of the law, but it is their job to make competent rulings on things like charter rights. The human rights and all this stuff was relevant in this case, but that particular issue, you can go in again to the record and see where I made that argument and see the tribunal just make a mess of it. And that's really too bad, because the compelled speech of professionals is a big deal, and everybody should be seriously concerned about it.
And so it goes that various regulators are still not following the science, despite the prestigious Cochrane review that concluded, using all existing and ongoing mask science, that community masking made little to no difference in how many people caught a flu-like illness / COVID-like illness. When will these heavy-handed mandate enforcers start to follow the actual science? For Rebel News, I'm Tamara Ugolini. A fun way to support our independent journalism while sporting some sassy swag is to head on over to our store at rebelnewsstore.com and purchase some gear. We have tons of freedom-loving designs and new styles out all of the time. For right now, you can use code Tamara, that's Tamara, Tamara10, to save 10% off of your total purchase. Head on over to rebelnewsstore.com and check out all of our swag there.